conference representatives from the Defence Force Welfare Association. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Kate Bowden here. I'm here as the National Treasurer of Defence Force Welfare Association.
My name is John Lewis. I'm the Queensland President of the Defence Force Welfare Association.
Del Gaudry. I'm the National President of the Defence Force Welfare Association.
Ms Bowden, did you have an opening statement that you wish to give?
Yes, I do. Thank you. Senators, ladies and gentlemen, my name is Kate Bowden and I'm here today with my colleagues representing the Defence Force Welfare Association, DFWA. DFWA is an independent voice for Australian Defence Force members, veterans and their families, and we advocate to government on matters affecting the welfare of this group of Australians, with a particular interest in government policy. DFWA's comments today specifically address Schedule 9 of the Treasury Law Amendments 2022 Measures Number 4, Bill of 2022. These amendments are trying to address a complex matter of superannuation and taxation law, and we welcome the opportunity to be part of this discussion. DFWA's position on Schedule 9 is endorsed by the Returned Services League Australia, RSL, the Australian Peacekeeper and Peacemakers Veterans Association, APPVA, and the Alliance of Defence Service Organisations, ADSO. While DFWA supports some aspects of Schedule 9, we also believe that the amendments as drafted will further embed inequity in the tax treatment of invalidity benefits for veterans. We are happy to provide examples of how a veteran's tax treatment varies depending upon their superannuation scheme or the start date of their invalidity payments. We believe that all veterans should be getting the same tax treatment of their invalidity superannuation payments. There are three areas of Schedule 9 which are supported by DFWA. Firstly, Schedule 9 removes any uncertainty and delayed action as a result of the Commissioner of Taxation versus Douglas decision of 2020. The Douglas decision has had a significant impact across the veteran community and was heavily supported by DFWA Queensland. The effect of this decision is that veterans' invalidity payments are recognised as lump sums with beneficial tax treatment instead of as a superannuation income stream. And this has had a positive impact for the majority of affected veterans. Secondly, Schedule 9 also extends the Douglas decision to revisionary beneficiaries, being the spouses and children of deceased veterans who were receiving invalidity benefits. And thirdly, Schedule 9 removes any potential disadvantage to a minority of veterans as a result of the Douglas decision through the implementation of a veteran's superannuation invalidity pension tax offset. This offset ensures that affected veterans are not worse off as a result of this change in legislation. There are two areas of Schedule 9 which are not supported by DFWA. Firstly, Schedule 9 enshrines inequity under legislation, where the date of payment of invalidity benefits determines whether a veteran will receive preferential tax treatment. The proposed amendments only apply to those veterans whose invalidity pay commenced on or after the 20th of September 2007 and do not go far enough to extend this treatment to members whose invalidity payments commenced before this date. These veterans have had the same service but will receive a different tax outcome as the result of this legislation. Secondly, the superannuation schemes covered by Schedule 9 are restricted, which means that newer members of the ADF will be unable to access this beneficial tax treatment. The amendments specifically cover the Defence Force Retirement and Death Benefits Act of 1973, DFRDB, and the Military Superannuation and Benefits Act 1991, MSBS. Since 2016, new members of the ADF have had no option to join these schemes and instead have access to insurance via ADF cover. At the time of closing access to MSBS, the government assured ADF members that ADF cover is designed to be consistent with the death and invalidity benefits provided under MSBS. Schedule 9 mandates a different treatment of invalidity benefits for those in ADF cover, and we believe this is against the government's intent at the time of its establishment. We suggest that the committee should extend the effect of the Douglas decision to those on ADF cover, being the younger contemporary veterans and those into the future. We also believe they should extend the effect of the Douglas decision to DFRDB and MSBS invalidity benefits that commenced before the 20th of September 2007, being older veterans, and should continue the inclusion of revisionary beneficiary inclusions and the veteran superannuation invalidity pension tax offset in any final legislation. Obviously, any amendments required to achieve these outcomes should need to be developed through Treasury. Thank you.
Thank you very much, Ms Bowden, for your opening statement, and I'll kick off with some questions. And I appreciate your opening statement where you say that there's some complexity here, and there are some parts of Schedule 9 that you support, and that there are some parts that you don't support. And I'll make sure that there's an opportunity for witnesses to speak to both today. And I might be a little bit in your hands, Ms Bowden, as to where best to direct the questions.
That's fine.
So just starting with the part of your submission, the aspects of the schedule that you support. You do support the part of the bill that confirms the Douglas decision, allowing veterans who received a lump sum to continue to receive their favourable tax treatment. Are you able to explain to us how this assists that group of veterans?
Well, sorry, John, feel free to jump in here. But from my perspective, there has been significant delays in whether it's CSC, ComSuper, or the ATO in implementing the Douglas decision. From the time that the court case was finalised in December 2020, ComSuper didn't start implementing that until May 2022. So I don't know that part is necessarily needed in legislation. The court decision has already been made and it has shown what the previous legislation exists. But if it assists government agencies in implementing the court case decision, then that is positive.
The Douglas decision benefited about 8,000 current people receiving the invalidity benefits, and there was about 400 who were adversely affected. And that is the law as it is at the moment, but it is just to a select group. Now, I can give you an example of the comparison of what happens. If we take, say, a member who joins at 18 with an annual salary of about 68,000, and then something goes tragically wrong, and they are injured, and they are medically discharged, and they're also certified as that they are most unlikely to ever work again in their calling due to their training or experience, and they have had an entire career prospect and plans for the future gone. Now, if that fella's discharged, or that veteran is discharged on the 22nd birthday, 2 doctors certify they're unable to be gainfully employed. Now, the invalidity benefit paid, regardless of the scheme, MSBS, DFRDB or ADF cover, the invalidity benefit paid is $63,000 per annum, roughly. And that is the same for each of those schemes, give or take about 100 a year. Now, those in ADF cover pay about $10,800 of that in tax. Those in MSBS or DFRDB with payments that started before 2007, they pay around about the same amount, a little bit less in tax. But those in MSBS where the payments started on or after the 20th of September get the beneficial treatment. And in this particular scenario, they would pay 0 tax on that element of their income. Now, the thing is, they get the same benefits. All of those get the same benefits, about $2,420 a fortnight. But after tax, they get about $1,995. So it's a difference of about $425 a fortnight for the rest of their life. Now, it's important to realise that these invalidity benefits are from CSC, and they are offset against any incapacity payments paid by DVA, which means that if they get these, the incapacity payments by DVA are reduced by the difference. These are just indicative examples, and everybody's situation is different, but it gives you a ballpark idea of the beneficial tax treatment. We just can't see there's any justification for this arbitrary discrimination against veterans who are all in the same boat. We think it has to be fixed.
Okay, thank you very much, Mr Lois, and that example that you gave with the specific benefit amount per year and how it applies to people in different categories is useful for the committee. Essentially, this schedule is about trying to fix a particular issue around a particular group of people affected around the Douglas decision, but is it your general submission that the benefits that flow from that to the particular group that was affected should now flow on to everyone, irrespective of whether they're pre-2007 and irrespective of what's the fund through which they receive their invalidity payments?
Yes.
Yes.
Our position. Sorry, our position is that the benefits paid by to veterans in receipt of an invalidity payment doesn't meet the requirement of a superannuation income stream. It is not permanent for life. It is revocable by the government, and it is not at a set salary. So given that it doesn't meet the requirements of an income stream in any of the superannuation streams which Defence Force veterans sign up to, this benefit should be applicable across all veterans in receipt of an invalidity payment.
Thank you. So
Can I just add a little bit there?
You can, yes.
The thrust, part of the thrust of this legislation is, in fact, it just reinforces an already existing court decision, but it also extends it to the families should that veteran die, and it fixes up a small number of veterans who are adversely affected. But I believe the main purpose of this is to prevent the spread of the Douglas benefits to a whole lot of other systems, and that was made pretty clear in the Minister's speech in the House, and it seeks to bound it and actually entrench the current system so that ADF cover can never be treated the same way. And I think it's quite a deliberate act on the government's part on this.
Okay. I'll come back to the evidence that you're giving on what you've just said about the broader consequences there as you see it, and your submission that this creates inequity between different groups of veterans. I do just want to go to the specifics of this schedule, and you mentioned, Mr. Lois, about how the schedule extends benefits to spouses and children in the event of the death of the veteran. Can you just explain your understanding of how that works and how that would assist a typical family?
Yes, well, if a veteran is receiving invalidity benefits and who's got dependents, wife, spouse, children, and if that veteran dies and he'd been receiving that beneficial tax treatment, if the veteran dies, the family receive what we refer to as reversionary benefits, which is a pension for the spouse and a pension payments to the children up to a certain age, 18 or 25. I'm not sure which. I think there's education criteria there. And this benefit of this legislation extends that tax benefit to those payments as well. Otherwise, they would have been excluded, and that's very welcome.
Okay, thank you. And again, I'll come back to your broader concerns that you've been giving evidence about today. You mentioned, Mr. Lois, the smaller number of people. I think you put a number of 400 or so on it who were adversely affected and liable to receive a negative tax outcome as a result of Douglas. Do you think that this does broadly fix that problem for that small group?
Yes.
Okay. And so your submission, if I understand it, is that while this schedule fixes these issues and extends benefit to families and allows those who received a lump sum to continue to receive their favourable tax treatment, your concern is that in trying to fix that, there's an inequity created between different groups of veterans. And so is it the case that you support the provisions of the bill but you'd like to see them extended? Is that broadly the submission?
Yeah, that's correct. We've got a situation now where most of the currently serving ADF, which is under strength at the moment, are either in MSBS, and I think there's a couple of hundred still in DFRDB, but everybody since 2016 are put into ADF cover. Now, you've got the situation where you could have two people serving side by side, both get injured or critically injured at exactly the same time, and they're medically discharged and they get exactly the same invalidity benefits, but lo and behold, one has to pay more tax than the other. And that's just nonsense for that to happen.
Okay, I think I understand the submissions that you are making from your written submission and from your evidence today. I don't think I have further questions. Ms. Bowden or other witnesses, was there anything that you think we didn't cover today that you wanted to make sure was on record for the committee?
Yes. Oh, sorry, go on. Sorry, Kate.
I was probably going to suggest that there were a number of other submissions that specifically addressed Schedule 9. I know some of them went into the legalities of why other schemes should be covered in terms of getting this beneficial tax treatment. So I would refer back to some of the submissions that have been provided by other parties as well against regarding Schedule 9.
Yeah.
Thank you.
If I could add just one other thing. We're specifically concerned about the equitable treatment of veterans currently serving together and those who have been medically discharged in the past. It just seems you would not design a system to produce that outcome if you're coming at it from the veteran viewpoint. And also, it's sort of created disharmony amongst what was harmony between the different acts, the different bits of legislation. And the Royal Commission into Veteran Suicide has got a focus on the complexity and the disharmony, and that matter needs to be addressed in veteran entitlement, not just DVA, but it says in the veteran entitlement system, and this is part of the veteran entitlement system. And we have now legislation which doesn't attempt to fix this disharmony, but instead entrenches it. And I put it to you that this goes totally against the spirit and the intent of what the Royal Commission is focusing on. And these veterans, they'll never work again. They have been medically discharged. They have been, in a sense, rejected by their team and kicked out, so they've lost all of their team support. It is a huge change for them. And they are the most vulnerable group at risk of mental health problems and suicidality. And this has been recognised in some of the reports submitted to the Royal Commission.
Yeah.
This goes against the spirit of the Royal Commission.
Thank you.
I would, if I could just echo the words of John and Kate, that the inequities here and also the mental anguish that may or does occur as a result of some of these things that can happen. So it's really about making sure that there is no discrimination regardless of which ADF superannuation fund that you're in, if a member is medically discharged through injury or illness.
Okay, thank you very much. Ms. Gaudry, Mr. Lois, Ms.
Sorry, can I make one last comment? Just in relation to the CPA submission, which recommended simplifying the tax treatment and removing the lump sum benefit for veterans and changing it into an income stream, we would object to that position. The reason that it's been recognised as a lump sum is because it doesn't meet the requirements of an income stream, and there would be further ramifications of what the government would need to do to change and make them non-revocable payments for invalidity benefits if that was a path that they wished to go down. But under the current arrangements for the superannuation scheme, where the government is able to revoke an invalidity payment or to change the amount of an invalidity payment, we fully believe that the lump sum approach is in accordance with the legislation that already exists.
Okay, thank you very much. I think through your evidence today, your written submission, your reference to other submissions as well, you've made your position very clear, and we thank you for that. I now welcome by video conference representatives from Chartered Accountants Australia and New Zealand and CPA Australia. For the Hansard, will you please state your full name and the capacity in which you appeared today? And we might start with the Chartered Accountants Australia and New Zealand.
Thank you, Madam Chairman. My name is Tony Negline. I am Superannuation and Financial Advice Leader at CAANZ.
Thank you, Mr Negline.
Thank you, Chair. My name is Richard Webb. I'm the Policy Advisor for Financial Planning and Superannuation at CPA Australia.
Either of your organisations have an opening statement, starting with you, Mr Negline.
Thank you, Madam Chair. I will defer to Richard to open proceedings.
Great. Mr Webb, thank you.
Thank you, Chair. And just to let you know, we will be, myself, Mr Tony Negline and Mr Ram Subramanian will be providing an opening statement jointly. We appreciate this opportunity to appear before the committee today and would be pleased to answer questions on our submission on the bill. Our submission is focused on Schedule 6 and Schedule 9 of the bill, and we will aim to address any questions from the committee on these parts of the bill. CPA Australia represents the diverse interests of over 170,000 members working in over 100 countries around the world. Whilst the submission which we made to this inquiry is on behalf of our members, our overriding responsibility as a professional accountancy organisation is to the broader public interest. In furthering the public interest, we work with regulators, standard setters, members and other stakeholders to address matters relevant to the accounting profession.
So Chartered Accountants Australia and New Zealand is a similar organisation to CPA Australia. We have around about 130,000 members working predominantly in Australia and New Zealand, but also like CPA Australia all around the world. We also advocate in the public interest, and many of our members provide a wide range of services to APRA regulated funds and also to self-managed superannuation funds. We might do financial and accounting, management accounting, tax, audit, investment advice and so on. Some of our members work for the tax office, for APRA and so on. But it would be fair to say that the majority of our 130,000 members are users of the superannuation system rather than working within it. So that brings us finally to Schedule 9. And now obviously Schedule 9 is in relation to the taxation of invalidity, mainly in relation to invalidity benefits from certain type of superannuation schemes. The complexity of Schedule 9 was borne out by the Burns and Douglas decisions before the AAT and also before the full federal court. Now, the problem we have with Schedule 9 is that we have the SIS Act and its regulations, we have the Income Tax 1997 and its regulations, and we also have very complex benefit design. And matching those three things together is not an easy exercise. And the problems that exist in the pension and annuity regulations in the SIS Act and its regulations and the taxation of those in the Income Tax Assessment Act have been a known problem since 2007, and our associations and others have over the years called for these matters to be thoroughly reviewed. Unfortunately, no government has actually acted upon those requests. From time to time, piecemeal changes have been made, for example, in 2018, as an example, to implement government policy initiatives or to plug holes that have emerged. Now, we think Schedule 9 is a missed opportunity, and after considering the submissions made by the various defence associations and other interested parties to this inquiry, we suggest that Schedule 9 should be removed from the bill for the time being, so the root cause problems created by ongoing inconsistencies between the SIS Act, the Income Tax Assessment Act 1997, and also the complex benefit design, not only of MSBS and DFRDB, but also of other similar type of schemes, such as the public sector superannuation schemes, can be thoroughly addressed and properly identified and addressed.
I'll just go to some questions around Schedule 9. I think in your submission, your written submission, you were welcoming broadly the clarity that the bill provides for the cohort of veterans that the bill, the schedule of the bill is dealing with. And then in your opening statement, you've described a missed opportunity to deal with broader issues around benefit design and complexity going back over 15 years, back to 2007.
That is correct.
I guess,
sorry.
I guess there's always a challenge for policy making about whether to try to deal with something that's in front of you and implement a narrow sort of solution to that, or whether to potentially hold that up for a much broader review of the type that you're seeking of 15 years of what you've described as complexity around benefit design. So I guess I'm, wondering what your concerns are really around proceeding with this clarification for this cohort of people now, and why you think that in some way might impede the broader policy discussion that you've raised. Can we not do both, fix this issue for this cohort now and then also engage in the larger policy discussion that you've flagged?
That is certainly, so it is certainly obviously open to the government, Senator, to actually do that, to make changes that are required in a piecemeal basis while there is a broader review going on. I guess our point is that we can continue to do the Band-Aid solution as Schedule 9 arguably is, or we can actually ultimately seek to fix the problems that actually exist at a broader level, which have been, as we said, sort of identified for over a number of years. So it's a balancing act. And I guess on balance, we decided that on reflection of looking at some of the submissions that had been made to the committee, that maybe there were a few elements of the bill in relation to how it affects some recipients of invalidity benefits was broader than what we actually expected. So we thought, hang on a minute, these sorts of problems are going to continue to exist for some time while we have the disconnect between the SIS Act, the Income Tax Assessment Act, and maybe to a lesser extent the complex benefit design that exists in these public sector schemes, but also potentially other schemes overall. So that's why we think it might be better long term to do the big job rather than do the Band-Aid job.
Okay, I think it's a reasonable policy position to take to suggest that a broader set of issues be dealt with, or that this be dealt with in a broader context. For the purposes of this particular inquiry on this schedule, can I just ask whether you agree that the measures, I guess, do what they're intended in relation to this particular cohort? So, it's trying to fix a negative tax outcome for a minority of veterans affected as a result of Douglas. It's trying to extend benefits to spouses and children, which was discussed by the previous witness. It's trying to maintain the favourable tax treatment for those who did have it. Are you broadly supportive of the schedule in trying to assist those groups?
I think our problem, Senator, is that we support Schedule 9 if it operates as intended and as you have just eloquently described. Our concern is that there are some individuals which we haven't quite got a handle on the size and how and so on and so forth because of the it's incredibly difficult to go through all of these different strands of laws and so on and make sure you've got all the ducks lined up. So we are concerned that there are some unintended consequences that, to be frank, we actually haven't got a handle on as yet. So that's our overriding concern. So we do support it, subject to what I just said. Our concern that maybe there's some problems that have been put into it.
Okay.
Problems that have accidentally come about as a result of trying to again do a Band-Aid.
Okay. I think you're describing in your submissions the sort of perpetual policy problem of trying to fix something in a narrow sense to get on with doing it, or trying to sort of address the whole complexity of something larger. And I guess in this case the government is trying to take initially a narrow view of fixing the Douglas decision in the way that we've described. I think your submission is raising, genuine policy questions about what's the best way to proceed to try to deal with all of the complexity assist those groups or assist those groups and then deal with the broader complexity. So that it seems like a fair submission that you've made. I think that